A very good evening to one and all. So today I'm going to discuss about one of the most important aspect of patent law, that is the patent claims, types of patent claims, claim construction, and interpretation. I will also be taking you through a landmark judgment case of Hoffman, Laroche versus Cipla, where the courts have summarized the principle of claim construction. So this is one of the important case because this also have been reiterated in many recent case laws. So before we move on to the case, let's first see what are claims. So claims. So these are the statements of technical facts expressed in legal terms, defining the scope of the invention that is to be protected. So a specification document is called as a techno-legal document. So it basically is a statement which expresses both technical aspect of the invention, which is being expressed in legal terms. So the patent claims are considered to be the heart of the specification and is one of the most critical part of the patent application. So these claims are usually a general, like a single sentence, which will end with a full stop. So it can be like a paragraph, which might be like a 2 pages, but at the end of the claim will be a full stop. And what is not claimed is always disclaimed. So now let's see what are the parts of a claim. So a claim is usually divided into 3 parts. The first part is the preamble. The next will be the transitional phase. The third will be the body of the claim. So first, let's see what is a preamble. Preamble, this is the introductory phrase that identifies the subject matter of the invention. So usually the preamble is we keep the preamble to be consistent with the title of the invention. And it also indicates the subject matter of the invention. So the next part of the claim will be the transitional phrase, which is the phrase which joins the preamble with the body of the claim. So this transitional phrase can be an open-ended phrase and a close-ended phrase. So I'll give you a detail about this open-ended phrase and close-ended phrase while we talk about the case law. Next will be the body of the claim, where we recite the elements of the claims. So whatever the limitation the claim includes, all the limitations and the elements of the claims will be recited in the body of the claim. So this body of the claim will show the different elements of the invention that is in relationship to one another. So let us now take an example of a claim. So we have a claim which says a water bottle cap comprising a base defining an opening, said base having a locking mechanism configured to engage said base with a bottle, a water outlet pipe, a water outlet pipe adapted to be received inside the opening, said pipe attached to said base, and a closure member engaged to said base. So here I have highlighted it in different colors. So here a water bottle cap. So that is basically the preamble of the claim. Then after that, whatever the next part of the claim is comprising. So that is the transitional phrase. And this transitional phrase is basically joining the body of the claim to the preamble of the claim. So next, the body of the claim will be a base defining an opening. And then the next element will be a water outlet pipe adapted to be received inside the opening. And then will be the closure member engaged to said base. So next we look into how a claim is written, as to what are the punctuations that are required in a claim. First, there will be a comma which separates the preamble and the transitional phrase. Then will be a colon, which separates the transitional phrase from the body of the claim. The next will be the semicolon, which separates the elements of the inventions. So now, if you take the previous example that we explained, so here talked about a water bottle cap. So a water bottle cap, that is the preamble of the claim. So the preamble of the claim and the transitional phrase of the claim is being separated by a comma. And then the elements of the claims, each element of the claim is separated by a semicolon. So now moving on to the types of claim. The first type of claim that we'll talk about is the independent claim. So this independent claim is it represents the broadest claim in a patent application. So this will be a standalone claim and will not need any limitation from another claim to be complete. So this claim is complete in itself. So now taking an example, an apparatus comprising a pencil and a light attached to said pencil. So this is a broad claim which is independent on itself. So it does not take any limitation from any other claim. So such a claim is basically called as an independent claim. The next type of claim is a dependent claim. So as the name itself indicates, the dependent claim will always be dependent on an independent claim or another dependent claim. So an example is an apparatus as claimed in claim 1, wherein the light is detachably attached to the pencil. So if you see in independent claim number 1, we are talking about an apparatus which has a pencil and a light attached to said pencil. Just a second. Okay. Yeah.
Yeah, is the screen share fine now? Rakesh sir, is it fine now?
Yes, it's perfect, Kavya. You can go ahead.
Okay, yeah, Anjali, you can go.
Okay. So yeah, I was talking about the dependent claims. So dependent claims will be a claim which is dependent from another claim. So that another claim can be either an independent claim or a dependent claim itself. So now by referring to another claim, this dependent claim will include everything from the parent claim plus whatever is newly recited in the dependent claim. So here in this example, we are saying that the apparatus as claimed in claim 1, wherein the light is detachably attached to the pencil. So whatever is claimed in claim number 1, that is an apparatus comprising a pencil and a light, and it also further comprises the elements that are there in the dependent claim. So the next type of claim is a multiple dependent claim. So these are basically the subsets of dependent claim, where the preamble of the multiple dependent claim will refer to more than one claim, where in this example, as you can see, the apparatus as claimed in claims 1 or 2, said apparatus further comprises an eraser. So basically we are referring to one or more than one claim. So here this is basically called as a subset of a dependent claim because it's referring to more than one claims. So the next claim is a product claim. So these claims are basically the claims which addresses an apparatus, a system, an article, or some object, or any other physical entities as such. So if you have a product that is to be claimed, so in such scenario, we use these product claims wherein we have explained it over an example, that is a chair comprising a seat, a backrest, and at least one leg. So we have a product here and we are claiming the product. The next element of the next type of a claim is a process claim, or which is also called as a method claim. So the method claim, it basically protects the process in which the invention is being performed. So so if you need to protect the method or the process, so it basically recites a sequence of steps. So if you have a process in which you're making a certain product, so that process is being claimed in a method claim. So like this example, a method of making tea, said method comprising boiling water, adding sugar to the boiling water, adding tea leaves to the boiling water, then filtering the mixture and adding milk to the mixture. So this is basically a process. So wherein if you have a process in an invention and you need to protect the process in such scenarios, we draft the claims as a process claim. The next type of claim is a product by process claim, where these claims claim for products which are defined in terms of a process of manufacture. So here the product as such should fulfill the requirements of patentability, where these type of claims are typically used for these chemical entities such as polymers or foods. So herein wherein we have explained with an example, that is a homogeneous and stable cereal suspension having the taste and aroma of natural oats, comprising intact beta glucans from the stating material and having a viscosity below 0.5 passer room temperature, obtainable by. So here we are defining the product by a process. So the next, obtainable by dry or wet grinding rolled oats or otherwise heat and water treated oats to meat. So this is basically a process. So here we are trying to claim for the product which is defined in terms of a process or process of manufacture. The next type of claim is omnibus claim. So this claim will not include any technical feature. So this type of claim includes only a reference to the description or drawings. So this claim will not talk any technical feature or like of the product or the process. It will just refer to the description or the drawings. So an example to this type of claim is that an apparatus for harvesting corn and as described in the description. So this will not give us any technical feature. It just talks about like the technical feature will be described in the description or the figures. So as the second example says, it is a juice machine as shown in figure 2. So there is no technical feature that is explained in this claim. It is just a juice machine as shown in figure number 2. So these type of claims are called a omnibus claim. The next type of claim is a means plus function claim. So here in this type of claims, functional language is being used to define a claim element. So rather than telling what it is, we basically define it through a functional language. So this means plus function type of claim, it can be interpreted both broadly and narrowly. Since the claims do not specifically define the structure, so it can be interpreted both broadly and narrowly. So, and the format of these means plus function claim. So this will include usually the word means, which will be followed by a function. So if you see here in the example, it says an apparatus for cooking rice comprising a means for holding rice and a heater configured to heat the rice holding means. So we are not talking about what that feature is. We are not talking about that element. Here we are just referring it to a means. We are keeping it very broad, telling that it's a means for holding rice. So it can be like a bowl or anything, but we are not referring it to as to what that element is. So that what that means is will be described in the specification. So we'll just refer it to as means followed by a particular function. So that type of claim is called as a means plus function claim. The next type of claim is the Jepson claim. which is also called as a two-part form, where these type of claims are usually a product or a process claim. It can be either a product or a process, where it in the preamble of the claim, we talk about the known prior art. So whatever is already known. So we are basically admitting that we know that this is already existing, and the improvement over the prior art will be explained over the prior art will be explained in the elements of the claim. As you can see in this example, it says a writing device comprising a pencil with two ends and an eraser attached to the pencil, characterized in that. So this term characterized in that will basically be differentiating the elements. So here, if you see, we are admitting that the pencil with two ends and an eraser attached to the pencil. So that is something that is already known, or something that is already present in the prior art. And after the characterized in that, whatever comes is basically the invention. So the eraser attached to one end of the pencil. So if we use the word characterized in that, so it is something that we're admitting whatever is before the term characterized in that is already known, and whatever is after characterized in that is something that is new. So these type of claims are called a two-part form. So there is an example which is a pencil having an eraser attached to one end of the pencil, wherein the improvement comprises a light attached to the pencil. So here we are saying that we are claiming an improvement over the prior art. So, and that improvement is a light being attached to the pencil. So this type of claim is called as a Jepson claim or a two-part form. Next, we look into Marcus claim. So these are the claims where if there are multiple alternative elements in a single claim, those claims are called as Marcus claims. So here, for example, we have in a claim wherein element A is selected from the group consisting of X, Y, and Z. So when there are multiple exclusive alternative elements in a single claim, so those type of claims are called as Marcus claims. So as an example, here we have said a fastener selected from the group consisting of a nail, a screw, and a rivet. So it can be either of these. So it can be selected from a group consisting of these three. So these type of claims are called as a Marcus claim. Next, we have a composition claim. So these basically claims a chemical nature of the material or the components being used. So like the example says, a copper electroplating solution comprising an alkaline solution of copper sulfate, which is 30 to 50 grams per liter. So these are the chemical nature of the materials. So the second element, which is sulfuric acid, 2 to 4 times the copper acetate solution, and then an aqueous solution of pH modifying substrate in an amount sufficient to adjust the pH to a value of 3.5 to 5. So this is an example for composition claim, which claims the chemical nature of the materials. So the next type of claim is the Swiss type claim. So this type of claim format is basically to cover if there are first, second, or subsequent medical use of a known substance or composition. So this is if you have a known like a known substance and you're talking about the use of it. So if your claim covers different use of a known substance, so in that type of claim is basically called as a Swiss type claim, wherein we have explained with an example, that is use of a substance X in the manufacture of a medicament for the treatment of condition Y. So this is basically a use of a known substance, basically a use of a known substance. So these are the different types of claims, and there are few claims that are not allowed in India. So these claims, basically every jurisdiction, like they have their own way of interpretation of the claims. So the claims, few of the claims which are not allowed in India are, the first one will be the omnibus claims, where in the claims, we don't talk about any technical feature, but refer to the specification or the drawings. So such omnibus claims are not allowed in India. The second one is the Swiss type claim, where we talk about the use of a known substance. So as you all know, section 3D, it's basically a it very clearly says that a use of a known substance is not patentable. So Swiss type of claim is also not allowed in India. The next type of claim is the means plus function claim. So this is basically completely at the discretion of the controller, because there are few means plus function claims which are allowed in India. But there are also few other claims of few other inventions where the controller has told us to specify what the means are. We cannot, like, the term means is very indefinite or ambiguous, and we'll have to define as to what that means is. So the main claims which are not allowed in India are the omnibus claims, Swiss type claim, and means plus function claim. So now that we know what are claims, the types of claims, I'll just refer to this case law, which is Hoffman, Laroche versus Cipla, which was decided in the year 2015. However, this is one of the important case because this case has been reiterated in many of the recent case laws also. So Hoffman Laroche had filed a infringement suit against Cipla, and in turn, Cipla had filed for a counter claim for revocation against Hoffman. So the first issue that was decided was about the validity of the claim, and later on the infringement. So while deciding the issue of validity of the claims, the court, the Delhi High Court decided this case. The court laid down certain principles of claim constructions. So I'll just point out to the relevant extracts. So from the case. So here from the case, here the court has said that, so principles of claim constructions could be summarized as under: claims define the territory or scope of protection. So as we had discussed earlier, so claims basically define the scope of invention that is to be protected. So whether an invention meets the patentability requirement or not. So that is determined based on the claims. Next is, there is no limit to the number of claims, except that after 10 claims, there is an additional fee per claim. So in India, there are 10 claims that are allowed. So in addition to 10 claims, there is an additional fee that is to be paid per claim. And claims can be independent or dependent. So as we have discussed, independent claim represents the broadest claim, and it will be a standalone claim. The dependent claim is the one that depends from another claim. So it can be either an independent claim or a dependent claim. The next point is that the broad structure of set of claims is an inverted pyramid, with the broadest at the top and the narrowest at the bottom. The next one is, patent laws of various countries lay down rules for drafting of claims, and these rules are used by the courts while interpreting the claims. So patent law, basically the interpretation of claims, it depends based on each jurisdictions. And one rule is that claims are single sentence defining an invention or an inventive concept. So as we had discussed earlier, so claims are always a single sentence that will end with a period, and the elements of the claims will always be separated by a semicolon. The first claim is a parent or mother claim, while remaining claims are referred to as subsidiary claims. So the first claim will always be an independent claim, which will be a parent claim or the mother claim, while the rest of the claims can be a dependent claim or a multiple dependent claims. If subsidiary claims contain an independent inventive concept different from the main claim, then the patent office will insist on filing a divisional application. So it is important to note that there should be only a single inventive concept. So if there are different multiple inventive concepts, and if it is in a single patent application, then either the patent office will insist us in filing a divisional application, or we can decide to differentiate those invention and file a divisional application. The next one is the subject matter of claims can be a product, substance, apparatus, or article. Alternatively, methods or process for producing said products, etc. They may be formulations, mixtures of various substances, including recipes, dosage, or in some countries, methods of use or treatment may also be claimed. So as you all know, we've discussed this where it can be a product claim or a process claim, the alternative methods or process for producing the product. And it can also be a mixture of various substances like these composition claims, or it can also be a treatment. So like they've mentioned, in some countries, methods of use or treatment may also be claimed, whereas in India, they don't usually allow these use claims. The next point is where claims are dependent, it incorporates by reference everything in the parent claim and adds some further statement, limitation, or restriction. So these are nothing but the dependent claims. So this will depend from another claim. Either it can be an independent claim or from a dependent claim. So by referring to another claim in a dependent claim, when we are referring to another claim, so which means the dependent claim includes everything from the parent claim or the mother claim, plus whatever is being cited in the dependent claim. So next is for someone wishing to invalidate a patent, the said person must invalidate each claim separately and independently, as it is quite likely that some claims may be valid even while some claims are invalid. So it is important to note that while invalidating a patent, it is not necessary that you're supposed to invalidate only the independent claim. So along with the independent claim, all the dependent claims are also to be invalidated. The last point is that at the beginning of an infringement action, the courts in the United States conduct what is known as a Markman hearing to define the scope of the claims or to throw light on certain ambiguous terms used in the claims. Although this is not technically done in India, but functionally, most judges will resort to a similar exercise in trying to understand the scope and meaning of the claims, including its terms. So this ambiguous terms, like I had referred to earlier, which are these means plus function claims. So claims should actually define the scope of the claim should define the scope of the invention. So we cannot use certain ambiguous terms in the claims. So wherein we have used these ambiguous terms in the claims, the controllers usually come back to us asking us to define. So usually these claims will be rejected, telling that it's very indefinite, and we'll have to define the term clearly in the claims. The next is basically during infringement analysis, there were two steps that were laid down. That was the first step is to determine the meaning and scope of the patent claims asserted to be infringed. So first thing is that we'll have to define, so we'll have to understand the scope of the patent claims. And the second step is to basically compare the claims with the device that is being infringed. So while having an infringement analysis, these are the two steps that is to be taken care of. The first one is to determine the scope of the claim. And the second one is to compare the claims with the device or the product of infringing. So the next point is that the parts of the claim includes its preamble, transition phrase, and the body. So we had discussed this earlier, where the transition phrase includes terms like comprising, consisting essentially of, having, and wherein. So this transition phrase is mainly divided into two phrases, which is open-end phrase and close-end phrase. Open-end phrases are the word comprising, containing, including, and all that. So those are open-ended phrases, whereas the close-end phrases are consisting of and all that. So using an open-ended phrase that is comprising. So the advantage of using an open-end phrase is that it expands the scope of claim by allowing other elements or limitations into it. Whereas if you're using a close-end phrase that is consisting of, so it will basically limit the scope of the claim, and the claims will cover only the elements that are named in the claim and not anything more. So that has been explained here. Of these terms, some are open-ended, such as comprising, which means that if the claims contain elements A, B, C, it would still be an infringement for someone to add the fourth element D. So using an open-ended phrase is basically giving an like scope, like it gives a broader scope of claim, whereas using a close-ended phrase, which is consisting of, gives very a narrow scope because the claim should cover only the elements that are named. The next one is each claim has a priority date, so that in a group of claims in a specification, you could have multiple priority dates. So, for example, if you have an invention which is filed on 11th Jan 2021, and another invention which is filed on 12th March 2021, you're combining these two applications and filing a set of claims. So each claim will have a priority date. So, for example, the first set of claims, if you have for 10 set of claims, the first set of claims, which is 1 to 5, will have a priority of 11th Jan 2021, and the second set of claims will have the priority date from 12th March 2021. So it is important to note that every claim will have a priority date. And this means that if a patent application with different claim and different priority dates, then if they were consolidated or cognate with another application, each claim would retain the original priority date. This has been explained in section 11 of the Patent Act. So these were some of the principles that were laid down in this case, which were considered for the infringement analysis and also for invalidating the for validating the patent claim.